Following the decision of Justice Muslim Hassan of the Federal High Court Lagos to hands off the case of former Aviation Minister Fani Kayode after allegations of bias, the Chief Judge, Justice Ibrahim Alta, reassigned the matter to a new judge, Justice Re-arraigns, also of the same court. When the matter came up de novo for the first time, the defense team informed the judge that they had pending applications challenging the court's jurisdiction. These applications had been filed before the previous judge, seeking a transfer of the case to Abuja, and so the defendants urged the court to hear the applications before taking their pleas. The EFCC counsel objected, insisting that the former trial judge had ruled on all applications, and this was the basis for the transfer of the matter to a new judge.
The issue is that they have applications which have been moved and ruled upon. That same application have been decided, they cannot bring it before the same court, except if they are filing another one, and they've not done so.
What his lordship said was that he was not even convinced that he was biased, as not to be able to take the matter, but because in the interest of justice, not so as to obviate the appearance of possibility of bias, he will recuse himself, that is, he will not decide the case at all. So the court did not pronounce on our application. And since it's a jurisdictional point, which can be taken at any time, then it's still open for argument here, because the motion remains in the file. It has not been decided one way or the other. It's not struck out.
In a ruling on the issue, Justice Aikawa ordered the defendants to take their plea and fixed the next adjourned date to hear submissions on the issue of the court's jurisdiction. In another case, another judge of the court, Justice Mohammed Idris, fixed May 24 to decide whether or not to hands off the case of one Christian Nwosu, an official of the Independent National Electoral Commission, INEC, who is charged with receiving the sum of 13 million naira from a former Minister of Petroleum Resources, Mrs. Deizani Alison Madueke. He and two others allegedly received various sums of monies as bribes for the purpose of compromising the outcome of the 2015 general elections. Mr. Nwosu had earlier admitted collecting the money in a plea bargain arrangement with the EFCC, but backed out after the judge rejected the terms of the agreement.
Section 270, subsection 15 of the Administration of Criminal Justice Act is clear and is unambiguous. It says where the defendant, decide to opt out from the plea bargain agreement, the proper order is for the judge to, transfer the case to another judge so that the trial, will continue de novo before that judge. We don't want to keep quiet on this and allow the defense to raise it later on, maybe after this court had finished with the entire proceedings.
The defendant has, however, rejected the request for the transfer. His lawyer says the purported plea bargain agreement was not done in compliance with the law, and so nothing stops Justice Idris from hearing the case.
My understanding of the ruling of his lordship was that the plea bargaining agreement was not in conformity with certain provisions of the ACJA, as it were. So the question is, our submission is to the effect that there was stricto sensu no enforceable plea bargaining agreement. And if there was no enforceable plea bargaining agreement, can you really withdraw from that, as it were?
Irrespective of how Justice Idris rules, the parties say they are ready for trial. Shola Shayeli, Channels Television News.